Greetings, everyone, and thank you for joining. We'll be starting in just a couple of minutes. Greetings, everyone, and thank you for joining. We'll be starting in just a couple of minutes. Greetings, everyone. On behalf of the Leadership Conference on Civil and Human Rights and Census Counts, I'd like to welcome you to our Census Seminar Series. This is Module 1, Census and Civil Rights. My name is Mita Anand, and I'm the Senior Program Director of Census and Data Equity at the Leadership Conference Education Fund and the Leadership Conference on Civil and Human Rights. Today, we are exploring the background of the census and its implications for civil rights. At this moment in time, we are aware that many of you are here as advocates, as policymakers, as funders, or as interested Americans and residents of the United States because you hear so much about the census, but you don't necessarily know all the intricacies. We have developed the Census Seminar Series in order to provide a further grounding and understanding about the census as you look towards 2030 and the American Community Survey. We have a really exciting panel with us today, and I just want to take this moment to thank all of our panelists who are truly experts in their field, and we really appreciate them taking the time with us today. Before I turn it over to our first panelist, just a few housekeeping items. This webinar is being recorded, and yes, the slides will be provided. Slides and additional resources will be available on www.censusroadmap.org. There is live captioning available, and please use the Q&A box to ask any questions you have today. We will be answering questions in writing in the Q&A box, and anything we do not get to today, we will be posting answers to on our Census Seminar Series webpage, which again, you can find on our Census Roadmap website. Today's hosts are nonpartisan 501c3 organizations. And once again, we're just really, really thrilled to have you, the audience, here, and we're thrilled to have our panelists here. So with that, I'm not going to waste any more time, and I'm going to turn it over with great pleasure to the former director of the Census Bureau, Jim Holmes. He will be providing us an overview of the American census. Jim, over to you.
Thank you very much, Mita, and good afternoon to all. Data from the decennial census and population and housing, as well as the American Community Survey, impacts almost every aspect of our lives. Participation in the ACS, or the American Community Survey, is critical, and it is just as important to participate in the ACS as it is in the census. The detailed population and housing data that was traditionally collected on the Census Bureau's long form from a sample of the population every 10 years is now being collected as part of the American Community Survey. The ACS provides detailed annual data instead of the data only being available every 10 years. So, why and how is the census itself a civil rights issue? I'm glad you asked that question. Civil rights are those rights associated with and guaranteed by the U.S. Constitution or U.S. law. The U.S. Constitution mandates that a census be conducted every 10 years. So being counted as part of each decennial census is a constitutional right, as well as one of our civil rights we're all guaranteed and entitled to. Now, some may have a less than positive reaction to the term entitled, but in this instance, it's all positive. It's just the opposite. As an example, the Civil Rights Act of 1964 prohibits discrimination on the basis of age, race, color, sex, religion, or national origin. Provisions of the Civil Rights Act also forbids discrimination on the basis of hiring, promotion, as well as firing. It also prohibits discrimination associated with public facilities and public places, which includes public schools as well, just to mention a few. But again, the question is asked, what does civil rights have to do with the census? The census, the decennial census that is the only national source of data that informs and enforces provisions and laws associated with laws like the Civil Rights Act of 1964. From a personal perspective, I was educated in a segregated educational system in the South, that is grades 1 through 12. I am also a proud graduate of a historically Black college. With that being said, the impact of laws such as the Civil Rights Act of 1964 are not at all lost on me. I recognize that my being hired as a statistician by the Census Bureau in 1968 was a direct result of the Civil Rights Act of 1964. I also recognize that that same law impacted my census career as well as many, many others, people of color around this country. Data items such as the Hispanic origin question. Some of us may take that question for granted, but that question was not asked of the entire population until the 1980 census. We don't even want to contemplate or think about what the negative civil rights implications would look like if we did not have Hispanic origin data today. These are just a couple of examples of why and how the census is a civil rights issue. We recognize that institutional and systematic racism is still alive and thriving. When you couple that with some of the safety nets that have been provided in the past are civil rights laws, and others are slowly being dismantled as well. The 2030 census will be an even more important tool for Black, brown, and underserved populations as we move forward to make sure that we are informed and, as necessary, take whatever necessary steps we need to do from an enforcement standpoint to make sure that our civil rights are protected. Thank you very much. And I will hand it off to Janine Abrams McLean, who is president of Fair Count and a fellow resident of our city and state.
Thank you so much, Jim. And hello to everyone. Today, I want to continue what Jim was just talking about and set the stage by providing an overview of why the census and its data are key to securing civil rights for everyone. As you know, civil rights are defined as the rights of citizens to political and social freedom and equality. And when we think about civil rights in the United States, examples include the right to vote, the right to government services, the right to a public education, and the right to gainful employment, and several other things. The census is a civil rights issue for several reasons, because it directly impacts political representation, the allocation of federal resources, and the enforcement of anti-discrimination laws. When you think about the census, particularly the decennial census, but also, as you've heard, the American Community Survey, you can boil it down to two main areas that directly impact everyone's civil rights: resources and power. And when the census is inaccurate, meaning that populations are undercounted or overcounted, resources and power are inequitably distributed. So with regard to resources, federal and state governments use census data to distribute billions of dollars in funding for public services, including education, healthcare, infrastructure, and social services. And so an accurate census ensures that resources are allocated back based on the actual needs of communities. One of the first things I learned about the census is that the money follows the numbers and not the need. And so undercounting can result in communities not receiving their fair share of funding, which then exacerbates existing inequalities. Regarding power, go back one. Regarding power, I'm referring to the political power and fair representation. The census determines the apportionment of seats in the U.S. House of Representatives, so an accurate count ensures that communities receive fair representation in Congress. Census data are also key to the redistricting process, where state officials redraw electoral district boundaries from political districts all the way down to school zones. Furthermore, census data are essential for enforcing civil rights laws, including the Voting Rights Act, which protects against voting discrimination. Census data help identify discriminatory practices, and they ensure that electoral districts are drawn fairly. And so undercounting marginalized groups, such as racial and ethnic minorities, can lead to unequal representation and weaken political influence. One way to think about it is a fair census count leads to fair maps, which leads to fair elections, and that's how you get real and equitable political power. So ensuring a fair and accurate census is fundamental to protecting and promoting civil rights. Next slide, please. So as I mentioned, an inaccurate census where populations are undercounted or overcounted is a major problem for securing civil rights. The history of census undercounts is marked by persistent challenges in accurately counting certain populations, particularly communities of color, urban and rural, low-income households, immigrants, and young children. These undercounts have significant implications for political representation, resource allocation, and civil rights enforcement. And so in the 2020 census, we saw undercounts in several populations. American Indians and Alaska Natives living on reservations were undercounted at a net rate of 5.64%. Hispanics and Latinos were undercounted at a rate of 4.99%. Black and African Americans were undercounted at a rate of 3.3%. And those identifying as some other race were undercounted at a rate of 4.34%. Again, these undercounts are not a novel issue. And as you'll learn in more detail later in this seminar, this pattern of undercounting BIPOC populations has persisted throughout the entire history of the census. Now, we also saw the persistent overcount of non-Hispanic white populations at a rate of 1.64%. Again, it is important to note that while there's a necessary focus on undercounts, historic persistent undercounts, the Census Bureau should also focus on mitigating overcounts, which are also inaccuracies that impact the equitable distribution of resources and political power. For the first time in the history of the census, there was also a significant overcount of the Asian population at 2.62%. However, experts and advocates have highlighted the need for high quality disaggregated data to fully understand which Asian subpopulations are overcounted and undercounted. And so to recap, persistent undercounts of BIPOC populations and marginalized communities in the census create substantial barriers to securing civil rights for all Americans. These undercounts undermine fair political representation, equitable resource distribution, and the enforcement of vital civil rights protections. And addressing these inaccuracies is critical for ensuring that all communities receive the representation, resources, and protections that they deserve. With the 2030 census happening in just a few years, the time to start planning better ways to accurately count everyone is now, or inaccurate data will continue to reinforce this barrier to securing civil rights for the next decade. Next slide, please. Lastly, I want to address the impacts of the newly revised race and ethnicity standards developed by the Office of Management and Budget that aim to enhance the accuracy of data collection to better reflect the country's diversity. These revisions include using a single combined question for race and ethnicity, adding a Middle Eastern or North African MENA category, and the opportunity for individuals to select multiple racial and ethnic categories that represent their identity. These changes, which are the first since 1997, let that sink in, will directly impact representation, resource allocation, and of course, the enforcement of civil rights laws. The revised standards aim to better capture diverse racial and ethnic identities. And so with regard to the census, these revisions offer a more nuanced categories and allow for multiple racial and ethnic identities to be reported, providing a more accurate reflection of the population that should, in theory, lead to fairer political representation. Improved accuracy in race and ethnicity data also allows for more precise allocation of federal and state funds because communities that are accurately counted can advocate for and receive their fair share of funding for vital services such as education, healthcare, and infrastructure. The revised standards will also provide more detailed demographic data that can be used to enforce the Voting Rights Act by helping identify and combat practices such as gerrymandering and voter suppression that disproportionately affect some communities. And while most advocacy groups generally agree that the new standards are a step in the right direction, there are substantial concerns that the revisions could undermine the accuracy for some historically undercounted populations. For instance, several groups are particularly concerned about how Black populations, such as Afro-Latinos, Afro-Arabs, and other Black immigrants will be counted under the new standards. So they are calling for additional research, testing, and community engagement to improve the standards and data accuracy. And so in closing, a fair census, accurate data, and improved race and ethnicity standards are indispensable for securing civil rights in the United States. They ensure that every community is accurately represented in the political process, that they receive equitable allocation of resources, and that these communities are protected under anti-discrimination laws. Enhanced data collection methods that capture the true diversity of the population allow for more effective policymaking and advocacy by addressing systemic inequalities and by helping ensure that all individuals, regardless of their race or ethnic background, are afforded the rights, opportunities, and protections that they deserve. Now, I'll pass it over to Dan Bouck, author and professor of history at Colgate University, who will go into the history of the census, undercounts, and apportionments. Over to you, Dan.
Hello. Uh, Thank you so much, Janine, for that introduction. I'm really pleased to be here with you all today. The task of counting 300 million people, over 300 million people, is really astounding when you think about it. The incredible activity that has to go into trying to find each person, counting them hopefully once and only once and in the right place. That count is also essential to the functioning of our democracy. I'd like to share some pieces today from the history of that foundational count and the struggle to make it more complete, inclusive, and better able to fairly allocate power and resources to everyone. I love this image, which was generated for the 1940 census. It is beautiful and it is silly. Now, this is one way to understand the census. People start over there on the right as individuals. They wear hats, some of them with feathers. The census places all of these people into households. And here, this illustration imagines a white nuclear family with a heterosexual couple. Now, in the process of counting, all these people join some sort of procession, and they lose their distinguishing features, except for this person with a pitchfork. And then they are, as best as I can tell, literally consumed by a gigantic book called Population Census. So it is a silly picture, but it captures a bigger truth. The goal of the census is to include each and every American, to allow us to be represented fully alongside our neighbors from far and wide, and to be subsumed into a national community. Yet even in 1940, when this cartoon was drawn, many people recognized that the census did not consume, or really count, everyone. Many people never made it into this grand procession, and the presumed whiteness of this crowd is also unintentionally revealing, because those who went uncounted were disproportionately people of color. While racialized undercounts are as old as the census, they were first proven to exist by 3 African-American researchers employed by the Segregated Census Bureau in the 1910s. Charles Hall, William Jennifer, and Robert Pelham looked at records of births and deaths in the South and showed that the figures generated in the censuses of 1870 and 1890 could not have been correct. They estimated that 10% of the white population of the South had gone uncounted, and that even more African Americans had been missed. The mathematician and intellectual Kelly Miller, a professor at Howard University, was inspired by these pioneering researchers and contributed his own analysis after the 1920 census results had been released. He too estimated a very substantial undercount of the BIPOC population. This at a moment when many social scientists used flawed statistics to argue for white supremacy. And so Miller shook his head in disgust that the census might advance that case, writing in 1922, "It is particularly unfortunate that such loose and unscientific propaganda can be bolstered up by data from governmental documents, which the uninquiring mind is disposed to accept with the authority of Holy Writ. The thought, and perhaps the conduct of the nation may be misled on the basis of erroneous data backed up by governmental authority." In 1947, a white researcher, Daniel Price, used a different method to arrive at the same conclusion. He compared the counts made for the draft in 1940 on the eve of World War II of fighting-age American men and compared it to similarly aged men in the census. The result showed a clear undercount of around 3% of the entire population and a shocking 13 to 15% for African Americans. Price thought the results would come as bad news to the, quote, advocates of white supremacy, who believed that at that time that the white population had finally outpaced the Black population in Mississippi. In the meantime, for officials in the Census Bureau, the problem of undercounting became a central concern. The Bureau designed two methods for estimating its own errors. First, they developed a special operation that would send census takers out into the field after the first decennial census had already been completed. It would survey a small subgroup of those previously surveyed individuals. This is called the Post-Enumeration Survey, the PES. And it would be used to compare with the original count from the census, and therefore could estimate what the census calls its coverage, the extent to which it has accurately captured the entire population. The Bureau also used data on registration of births, deaths, and migration in a procedure called demographic analysis to see if the actual census counts matched the numbers that the existing rates of population change would have predicted. This was actually very similar to the kind of method that Hall, Jennifer, Pelham, and Miller had used to discover the racialized undercount in earlier decades. In the 1960s, census results took on new significance. The federal government began distributing more and more funds to states and communities in proportion to census counts. Right? The funds follow the numbers, as Dr. Abrams-McLean told us just a moment ago. And the Voting Rights Act and the one person and one vote decisions of the voting rights revolution rested on accurate data. And here, Director Holmes talked about this just a moment ago. So cities sued the Census Bureau en masse after the 1970 census, claiming harm based on undercounts. The academic question of census accuracy from earlier decades had become a legal imperative. The Census Bureau developed advanced statistical techniques that could adjust for errors after the fact, beginning in the 1980s. But then the courts, including the Supreme Court and also Congress, intervened. Ultimately, Congress made it such that it is not presently allowable to use statistical estimates to apportion seats in the US House, yet population estimates can and are used for other important purposes. And in the meantime, the Bureau works with people and groups, many like people who are probably attending the series, to try to get every person and community counted. It is neither easy nor straightforward to find a person and translate them into data that can serve our communities and our country. For much of the history of the census, that act of translation required that a person, a census taker, would arrive at each household, each doorstep, and gather information directly. This painting from 1854 presents one such moment. It hangs in New York's Metropolitan Museum of Art. Note the family patriarch in the center of the frame, counting on his fingers, while a census taker waits with a quill in hand. And look at the children off to the side, hiding and smirking. Everyone in the house is wondering the same thing. Can father name all of his children? The 1850 census was the first to record the full names of every free person counted. Before that, most people showed up only as a tally mark. We don't know if this father succeeded in this task, but this painting was at its time a joke and a social commentary, one that marked a new hunger and new demands for data about individuals. Nearly a century later, the poet Langston Hughes depicted another doorstep encounter. Let me read this poem, first published in 1944. The census man, the day he came round, wanted my name to put it down. I said, Johnson, Alberta K, but he hated to write the K that way. He said, what does K stand for? I said, K, and nothing more. He said, I'm going to put it K-A-Y. I said, if you do, you lie. My mother christened me Alberta K. You leave my name just that way. He said, Mrs., with a snort. Just a K makes your name too short. I said, I don't give a damn. Leave me in my name just like I am. Furthermore, rub out that Mrs. too. I'll have you know, I'm madam to you. It is a brilliant, a beautiful, a funny poem. It reminds us, though, that the act of being counted could be, often is, fraught. The people with the power of the pen might refuse to see a person as they have seen themselves. Counting always requires negotiation and sometimes struggle, and it can be a matter of strategy to think about how one should be counted or would like to be counted to best support one's community or communities. Beginning in 1960, the Census Bureau changed the primary mode of enumeration. People would answer the questions directly on paper and now online or by phone. Those who did not respond and people living in certain areas would still meet a census taker face to face. But such doorstep encounters were no longer meant to be the norm. Bureau officials hoped that this change would give them more control over the count and would get rid of error caused by enumerators, even if it introduced some new errors from ordinary people filling out these forms. They did not intend to create a new possibility for self-definition, and yet that is also what happened. Self-enumeration grew into the policy supported by many census advocates that individuals should be given the power to identify their race and ethnicity. That change has been tied to a long struggle to expand or refine possible racial and ethnic categories, as we just heard about, and whether individuals may choose more than one such category. One goal has been to make the encounter with the census form less fraught than it was for Alberta K. Johnson, and yet, inevitably, some frustration persists. No person can be represented perfectly by a data set. This is one important argument for the Census Bureau's commitment to confidentiality, which keeps all individual data secret for 72 years, even from the rest of the government. Our individual records are to a certain degree flawed and should not be used to make decisions about our lives. Yet they are good enough, more than good enough, to generate larger, very powerful and accurate truths about our communities and the nation in aggregate. Many of you who are watching this talk, this series, are part of the enormous effort to make it so that this procession of people includes everyone and allows our communities to be accurately represented in a manner more consistent than this illustration with the diversity of the American people. Today, we will be hearing about many reasons, and we have already heard about many reasons that census data matters, from allocating resources to allowing for the drawing of fair legislative districts that protect the voting rights of people of color. The original reason the census came into existence, though, was for the purpose of determining how many seats in the House of Representatives that each state should have. That number also becomes the number of votes that each state has in the Electoral College, plus one vote for each senator. The census is meant to ensure that political power is proportional to the number of people in each state. The Constitution, in its very first article, created Congress and said that the House of Representatives should be determined based on the numbers of people, excluding a group that it called Indians not taxed, and counting enslaved people as only 3/5 of a person. After the Civil War, the U.S. passed the 14th Amendment, granting citizenship to formerly enslaved people and removing that 3/5 distinction. The Constitution now based representation on, quote, counting the whole number of persons in each state, excluding Indians not taxed. With the 1940 census, the Bureau decided that all Native Americans in the United States should be counted towards apportionment numbers. These days, as we see recently, politicians pushing to exclude people from apportionment counts because of their immigration status, and this is not for the first time, but prior efforts to exclude non-citizens have eventually realized that such a radical change would require amending the Constitution. The 14th Amendment clearly requires counting all persons, full stop. For most of the first century of American history, Congress deliberated about census results and used them to pass new legislation, declaring a new size for the U.S. House of Representatives while apportioning seats by population. This usually meant making the House larger as the population of the nation grew, and it very often entailed picking a size for the House such that few or no states would lose any seats in the House. That changed when congressional leaders decided to freeze the House at 435 seats, and the subsequent efforts to apportion in 1920 failed. With the 1930 and 1940 censuses, Congress developed an automated system for apportioning the House, such that it remains steady at 435 seats and effectively removes Congress from the process of apportioning representatives. We can see one result of that shift in this graph here from usapportionment.org, in which the population has more than tripled while the number of seats has stayed the same, such that each representative now stands in for over 700,000 constituents. Another result has been that political disputes over representation have shifted from Congress to the courts. Most censuses since 1940 have resulted in at least one significant Supreme Court case challenging the results of the apportionment. This is a natural result from Congress's decision to remove itself from a major political process, one that pits states against other states. Of course, there are also reasons to contest census results in courts because of concerns about equal representation, civil rights, and equitable allocations of funding. But those are aspects that I'll leave to my more capable colleagues on this panel. Indeed, next up is Andrea Centino from MALDEF, who will talk about what these data mean for civil rights enforcement. Thank you.
Thank you so much. Hello, everyone. I am the Regional Counsel of MALDEF's Washington, D.C. office. It's so nice to be here with you today. For 56 years, MALDEF has worked to promote the civil rights of all Latinos in the U.S. MALDEF focuses its work in four subject matter areas: education, employment, immigrants' rights, and voting rights. And MALDEF has a long history of litigating to enforce the civil rights of Latinos and challenge discrimination, as well as advocating for laws, regulations, and policies that advance civil rights, equity, and opportunity for all. Today, I'm going to discuss the importance of decennial census and American Community Survey data to civil rights enforcement, with some examples of how we use that data in our work at MALDEF. I'll then explain how decennial census data is used for congressional apportionment and redistricting, which also makes use of data from the American Community Survey. And then, given the continued political discussions about citizenship data, I'll touch on that issue and review some of the more recent litigation challenging the Trump administration's unsuccessful attempt to add such a question to the 2020 decennial census form and its unsuccessful attempt to later collect citizenship and immigration data through administrative records. Yeah, thank you. So I want to address why we need race and ethnicity data. The federal government collects race and ethnicity data in order to create and report that data to provide the public and policymakers with a picture of what the population looks like nationally or within geographic units. It also uses this data to create estimates of other characteristics disaggregated by race and ethnicity, so that we can better understand disparities or distinctions within our population broken down by race and ethnicity. This might look like educational attainment broken down by race, or home ownership broken down by race or ethnicity. This data is used for a number of different things. Local, state, tribal, and federal government entities use that information to do things like conduct research or establish funding or services through government programs for certain population groups. And this data can also be used to help government agencies or entities assess programs and policies to make sure that they operate fairly and equitably. It's also used to monitor compliance with various anti-discrimination laws, regulations, or policies. Previous slide, please. Some of the uses for race and ethnicity data in civil rights enforcement, for example, include race and ethnicity data is used to monitor and enforce compliance with the Voting Rights Act, such as its language access requirements, which I'll discuss in more detail in just a moment. This data is also used to monitor and enforce compliance with the Civil Rights Act, such as ensuring equal employment opportunities for all regardless of race. And race data is also used to identify populations that may experience differences in access and opportunities based on their race or ethnicity. For instance, it's used to identify disparate health care access, health quality, or health outcomes for different racial groups. And with disaggregated data, we can also see disparities that might exist within a racial or ethnic group. This data is also used to enforce anti-discrimination laws and regulations in many different areas of the law. For instance, it's used to enforce anti-discrimination protections in education, employment, voting, financial assistance, and housing. And it's used to investigate the existence of disparities in education, housing, employment, homeownership, health, income, and other areas based on race or ethnicity. Next slide, please. And so I want to discuss one example of the use of this data. Congress added Section 203 of the Voting Rights Act in 1975 because it found that various practices and procedures excluded citizens of language minorities from participating in the electoral process. In order to enforce the guarantees of the 14th and 15th Amendments of the U.S. Constitution, Congress found it necessary to eliminate this type of discrimination. And so this provision of federal law requires that whenever a state or a political subdivision that is covered by the section provides registration or voting notices, forms, instructions, assistance, or other materials or information related to voting, including ballots, that it has to also provide those items in the language for the applicable language minority group in that area in addition to English. And so this protection applies to the following language groups: Latinos, Asian American, American Indians, and Alaskan Natives. The list of covered states or localities is updated every 5 years. And the requirements in this section apply to all localities where there are more than 10,000 or over 5% of the total voting age citizens in a single political subdivision. That's usually going to be a county, but it also might be a township or a municipality in some states where members of a language, who are members of a language minority group, or in the case of a state where it exceeds 5% of all, in the case of Native American language minorities, it exceeds 5% of all reservation residents on Indian reservation, and also where the illiteracy rate of citizens in the language minority group is higher than the national illiteracy rate. Section 203 determinations are made using data from the American Community Survey or comparable census data. And more specifically, the Census Bureau uses data from the American Community Survey to classify individuals based on voting age, citizenship, limited English proficiency, and illiteracy. Section 203 is an important provision for ensuring that all eligible voters are able to cast a ballot regardless of their English language proficiency. Next slide, please. I want to move to how census data is used for things like apportionment and redistricting. Decennial census data, as you heard earlier, is conducted every 10 years with a census count, and it is the count of the entire U.S. population. This is also known as an enumeration. The purpose of the decennial census is to determine congressional apportionment and redistricting, among other uses. And congressional apportionment means the division of seats, among the states, and how many representatives each state will receive in the U.S. House of Representatives. As you know, this number can change for a state every decade, depending on population shifts across the 50 states. And decennial census data is also used to redistrict. It's used to ensure that redistricting plans also do not discriminate based on race and thus that they comply with the Voting Rights Act. Next slide, please. And I want to talk a little bit about the difference between the decennial census count and the American Community Survey, or the ACS. The ACS is a sample survey by the Census Bureau, not an actual enumeration. The ACS gathers information from a sample of over 3 million housing units annually on a rolling basis. And the Census Bureau uses the ACS to create multi-year estimates about important characteristics of the population across the country. Information collected is similar to the decennial census, but not exactly the same. For example, the Census Bureau collects data on citizenship through the American Community Survey, but not on the decennial census form. The ACS provides data about various characteristics and subjects, like citizen voting age population, languages spoken at home, employment status, poverty status, educational attainment, and much, much more. It's an important tool for governments, policymakers, the public, and organizations like MALDEF in identifying progress or disparities in the U.S. population, broken down in a number of different ways. Next slide, please. So one of the uses for both decennial census data and ACS data is in the redistricting process. Redistricting is the process by which states and jurisdictions within them redraw the lines that encompass electoral districts. Decennial census data is used to redraw district lines after each census every 10 years, and the ACS data is also made available for redistricting. For example, decennial census data and ACS data are used to produce citizen voting age population data, which can play a role in redistricting. State governments, redistricting committees, community organizations, and residents can all use census population data in the redistricting process. And the decennial census data are provided at the block level, the finest geography level used by the Census Bureau in reporting data. Next slide, please. So the racial makeup of voters and communities in redistricting plans is subject to an array of different laws and considerations. And it's important to know that redistricting for congressional, state, and local bodies everywhere in the United States must comply with the Voting Rights Act. Section 2 of the Voting Rights Act prohibits voting practices that have a racially discriminatory intent or discriminatory results. So if a redistricting map disadvantages people of color through vote dilution, that map violates Section 2 of the Voting Rights Act. Race can't be used as the sole or predominant basis for drawing any district without a compelling justification, such as protecting minority voting rights. So in that regard, Section 2 of the VRA requires the consideration of race among other factors to ensure that Black, Latino, Asian American, and Native American voters have an equal opportunity to participate in the political process and elect their candidate of choice. The U.S. Attorney General, the private citizens, community groups, or organizations can sue to make sure that redistricting plans comply with this law. And as I mentioned before, ACS and decennial census data are combined to produce a data set that includes information about the citizen voting age population. This is important because in order to determine whether a redistricting plan violates Section 2 of the Voting Rights Act, and because it has the effect of discrimination, courts are required to use a two-part test. And the first part of that test, the test which is also known as the Jingles factors, because they were first announced in the Supreme Court case Thornburg versus Jingles. In certain federal appellate circuits, that data, that citizen voting age population data, is required in order to determine whether a population constitutes at least 50% of a district. And this is required in order to meet the first prong of that Jingles test. So the use of ACS and decennial census data has an essential role in establishing that a redistricting plan violates Section 2 of the Voting Rights Act. And so I'll just briefly touch on two examples of from some of MALDEF's previous work and how that data helps show that there is a violation or that there was a violation of Section 2 of the VRA. The first one is Abbott v. Perez. This is in 2011, the Texas legislature, in response to requests from Latino advocates, created a new Latino majority congressional district in South and Central Texas to reflect that state's increase in the Latino population and in order to avoid violating Section 2 of the VRA. The incumbent Democratic Congress member there in an adjacent district and others filed suit and challenged the new Latino district. And it argued that it was predominantly, the drawing of that district was predominantly based on race and not justified by the need to avoid vote dilution. But in 2018, the Supreme Court upheld the new Latino majority congressional district because it ruled that Latino voters indeed had satisfied all the criteria to justify creating that new Latino majority district. This is an example where considering race in order to draw a majority-minority district as a remedy for vote dilution is permissible. And an example of the use of data on population, specifically citizen voting age population as well, that is generated from the decennial census and the American Community Survey, how it gets used to ensure that all voters are afforded the opportunity to meaningfully participate in elections. Second, I'll just touch on a very recent case from our MALDEF office in Los Angeles. MALDEF, the Campaign Legal Center, the UCLA Voting Rights Project, and Eduardo Morfin of the Morfin Law Firm filed a lawsuit in January 2022 on behalf of individual Latino voters in the Yakima Valley in Washington State. Washington State drew legislative redistricting lines that ignored the substantial growth of Latinos in the Yakima Valley over the last decade, and thus denied them the ability to elect representatives of their choosing. Using decennial census data and American Community Survey data, again, as part of the test required for making that showing of a Section 2 violation, the plaintiffs there were able to show that the growth of the Latino population in the Yakima Valley was substantial and that a legislative district could have been drawn to provide those voters a realistic chance of electing their preferred candidates, and ultimately was able to make all of the showings required that there was a violation of the law there. So these are important uses of both of these data sets in order to enforce civil rights. Next slide, please. So turning now from some of the information that I just talked about that is collected through both the decennial census and the American Community Survey and how it's used to enforce civil rights, I turn now to data that we do not collect on the US decennial census form, and that is citizenship data. Citizenship data is collected through the American Community Survey, along with data like place of birth or year of entry data. And when it's collected through the ACS, this data in combination with other data helps the government and others enforce laws, regulations, and policies that protect against national origin discrimination. Next slide, please. And so I raise this now and want to just quickly review some of where we found ourselves at the end of the last administration with respect to citizenship data. Some of you may be familiar with the Supreme Court case, Department of Commerce versus New York, which was decided by the Supreme Court in 2019, in which the Supreme Court ruled that the Trump administration's attempt to add a citizenship question to the 2020 decennial census form was based on a pretextual justification and thus violated the Administrative Procedure Act. But there were a number of other cases that were also brought challenging the addition of the citizenship question to the 2020 census form. One of those challenges was brought in the District Court of Maryland by MALDEF on behalf of community organizations as well as individuals who would be negatively affected. And that was La Unión del Pueblo Entero versus Ross, which was later consolidated with a case called Kravitz versus Department of Commerce. And in our case as well, the district court similarly ruled as it did in the Department of Commerce versus New York case, or I should say the New York versus Department of Commerce case, the district court ruled that the attempt to add this question was a violation of the Administrative Procedures Act. Our court also ruled that it was a violation of the enumeration clause of the U.S. Constitution, which you heard discussed earlier. And there, we moved along and appealed the ruling by the district court against our intentional discrimination and conspiracy claims. And later, as new information came out throughout the process or in litigation in 2019, plaintiffs there sought to go back to the district court, given new information that indicated more coordination between political operatives and the administration in attempting to add the citizenship question to the decennial census that we believed would at least merited reconsideration of the court's prior rulings with respect to intentional discrimination and conspiracy. Eventually, the Trump administration abandoned placing a citizenship question on the decennial census. I'll note that this was after the litigation in our case in Maryland was headed towards renewed discovery, and the court there had actually ordered the opening of a discovery period limited to the question that I just raised here, which was whether or not there was other evidence that really showed the intent of the administration to discriminate against certain individuals by adding the citizenship question to the 2020 form. And so the Trump administration, facing what would have been a renewed or a reopened discovery period, eventually abandoned its attempt to put a citizenship question on the form, but the president did direct the Department of Commerce to collect citizenship and immigration data through administrative records at that time. Next slide, please. And so MALDEF and our partners at Asian Americans Advancing Justice, which also participated and were our partners in the first Lupe case, we joined together and similarly sued the administration on behalf of groups seeking to ensure a full count and challenging that directive to collect citizenship and immigration data using administrative records, as well as guaranteeing the inclusion, in order to guarantee the inclusion, I should say, of all persons, including undocumented immigrants, for the purpose of apportionment. Ultimately, we all know that the Trump administration was unsuccessful in its attempts both to add a citizenship question to the decennial census and to collect information about citizenship and immigration status through administrative records that it had sought to use in order to subtract certain individuals, specifically non-citizens or undocumented immigrants, from the total population count. But it's important that, we look at these challenges, considering the continued discussion about citizenship data on the census form. And then I'll just briefly end with a note that, not all of the litigation that was brought, right, was in order to stop attempts to capture this data and subtract non-citizens from the total population count. The state of Alabama actually sued the Department of Commerce and other federal representatives or officials, I should say, in order to challenge what was the 2020 residence criteria, which stated that all non-US citizens who resided in the US at the time of the census would indeed count towards the population count. And this was an attempt by the state of Alabama to force what the Trump administration was seeking to do, which was to subtract non-US citizens from the total population count for the purposes of apportionment, which you heard Dan talk about earlier, the requirements of counting all persons when it comes to the apportionment count in the US Census. And so we, continue to take any threats to the integrity and the completeness of the decennial census very seriously, but certainly look forward to a 2030 census where we are able to ensure a complete count of everybody, including a complete count of the Latino population, because this data really is so very critical to our ability to enforce civil rights in a myriad of different ways. And now I will pass it to Thomas Wolf.
Hi, everyone. I'm Tom Wolf. I'm Director of Democracy Initiatives at the Brennan Center for Justice, where I also founded our census project. We do a mix of litigation, research, including legal research and history research, and also some policy advising for other groups who work in the census space. I'm going to sort of clean up here, talking about some of the underlying or sort of structuring Supreme Court opinions that influence both the ways that advocates for the census go about advocating for the census, and also influence the way that some folks have in the past tried to attack the census and may try to attack it in the future. Because of the great presentations that you've heard from the folks preceding me, we've covered a lot of the basic terminology, but I'll try to slow down at various points to sort of reiterate some of that, just so it's as clear as I can make it, what the state of the law is and what these cases are about. But a couple of the key concepts to keep in mind as we go through this will be the apportionment, redistricting, as well as the concepts of undercounts. So there's a small but meaningful body of Supreme Court case law on the census. I want to focus on the cases that have the biggest implications for civil rights. There's essentially two clusters of cases that we should pay attention to if that's going to be our lens onto the situation. The first cluster deals with who is supposed to be counted in the census, and the second deals with the techniques available to the Bureau or not available to the Bureau, as the case may be, to ensure a complete count. So taking the first cluster first, these are the cases concerning who counts. The key cases here concern citizenship questions and the apportionment base. Now, when I talk about the apportionment base, again, that's the population count that's used to determine how many seats each state gets in the House of Representatives when those seats are reallocated every 10 years after the census. So citizenship questions. Andrea also already covered a lot of the details. I think the main thing that I want to put out there is that all of this very intense litigation around the census generated a Supreme Court opinion on the issue. The practical effect of that Supreme Court ruling was to block the Trump administration from putting a citizenship question onto the 2020 census. This opinion came out very late in the court's term, shortly before the final printing needed to happen. Trump tried to engage in a variety of ways and saber-rattled about moving forward there, but the court's opinion put a huge roadblock in his way that prevented them ultimately from moving forward. That ultimate kind of result is based on three different legal rulings in that case. The first one, and the most important one, because it was dispositive, was that the Trump administration's attempts to add the citizenship question violated the Administrative Procedure Act, which is a federal law that seeks to ensure that government decision-making is evidence-based, transparent, and also done with a lot of dialogue and discourse with the public. Essentially, the Trump administration for a very long time had been claiming that the reason why they wanted the citizenship question was to enforce the Voting Rights Act. As it turned out, that was a pretext. The real reason why the administration wanted it was because it was going to facilitate various attempts to increase Republican representation, or so they thought, at least. So the court said, you can't do that. If you're taking actions like this, your reasons for doing them need to be the real reasons, so you can't move forward on that basis. However, there were two other rulings that I think will be important to keep in mind when we think about risks going forward. One was a ruling from the court that the Constitution's enumeration clause didn't block the question And the court also ruled that, in my view, the administration's failure to comply with a couple of deadlines that are set forth 2 to 3 years ahead of the census to make clear what questions and topics are going to be on the census didn't really have any teeth. So we managed to escape, with the outcome we wanted, but some of these rulings linger, and I'll kind of circle back to them at the end of my talk. The other major issue to keep in mind here is the question of not just the citizenship question, but citizens-only apportionment. So again, part of the reason why the citizenship question was sought was to facilitate attempts to remove non-citizens from the numbers used to apportion Congress. And so there was this separate push after Trump did not succeed in getting the citizenship question to generate data by other means that are sort of unclear to identify the number of non-citizens in the country and attempt to remove them from the count, essentially after the Bureau presented it to him and before it went to Congress. That was also resulted in a Supreme Court case in the kind of waning years of the Trump administration, the last couple of weeks of 2020. Obviously, there was a lot else going on in the country at that time. What happened there was the Supreme Court dodged the issue about whether it would be legal for the president to exclude people. He ruled that the lawsuits that were challenging this scheme were not yet ready to be brought because it was unclear what Trump was trying to do and whether he would actually do it. Now, this is a critical thing to keep in mind. The court did not say that it was legal for Trump to do this. It actually said, we're not taking an opinion on this at this time, and they ended up never having to delve into it because Trump ultimately never was able to follow through. Nothing more happened on that front before he left office a few weeks later. But this should be a very easy question, and there seemed to be some amount of hesitancy on the court to just nip this in the bud. And so that is also something that I keep in mind as a lawyer when I'm thinking forward about what sorts of threats may exist. But again, very clearly, the Supreme Court has not said that this would be legal to exclude undocumented people from the apportionment count. All right, so that's one cluster. The second cluster refer to the Supreme Court's counting methods, like the actual techniques it uses when it goes around counting people and determining the numbers that it's going to present for apportionment and redistricting. These combine to put some real limits on what the Bureau can do to respond to undercounts, whether they're differential undercounts or otherwise. And I think as a result, this body of law is really important to keep in mind when we're thinking through questions that come up every decade, including how can the Bureau respond to undercounts? Is it possible to fix the numbers on the back end? If so, what methods can you use? The court, hasn't provided crystal clear guidance on this, but over the course of several decades, it's issued a few different opinions that suggest at least certain avenues are either not available or maybe more complicated. And they've also said that some things are all right. So highlighting that none of this necessarily makes sense read together because they're not the product of a single court at a single time. They're the result of several different groups of justices weighing in on issues over the course of several years. The first technique, sampling. So in the 1990s, the US Supreme Court ruled in a case called Department of Commerce v. US House of Representatives that the Census Act didn't permit statistical sampling for apportionment purposes. What that means is that the court said that federal statutory law wouldn't allow the Bureau to determine how many people are in the country for purposes of apportionment just by polling a subset of them. In other words, you can't say there were fewer people in the country during that time than I'm about to throw out there, but 350 million people, we arrived at that number just by sending forms to 35 million and then sort of extrapolate it from that sample into the total population number. The court said that's not going to fly. Congress won't allow it. Now, that's a statutory ruling. It's not a constitutional ruling. Theoretically, Congress could change the law to make it legal, there's still this open constitutional question about whether sampling would be legal. Right now, it's illegal as a matter of statutory law. And as a result, particularly, in this past decade, it was not sort of on the table as a potential solution to problems with undercounts. Second category, statistical adjustment. So on the flip side, the court has also said at another point in time that the Constitution doesn't require statistical adjustments to fix undercounts. So this is basically talking about a scenario where after the numbers are produced, the Bureau adjusts them in some ways to account for what it knows about potential undercounts. Say if they believe a group was undercounted by 5%, boosting their numbers by 5%. In a case called Wisconsin v. City of New York, the Supreme Court ruled that the Constitution gives Congress really wide latitude to administer the census, and that the Census Act gives that broad authority to the Commerce Secretary, who, keep in mind, the Department of Commerce is where the Census Bureau sits. What that means is Congress and the Commerce Secretary can do a lot in terms of the decisions they make about how they run the census. But in the court's language, so long as the Secretary's conduct is consistent with the constitutional language and the constitutional goal of equal representation, it's within the Constitution's limits. So in this case, folks had been pushing the Bureau to statistically adjust. The Bureau didn't want to do it. Folks sued the Bureau over that, and the court said their decision stands, that they're allowed to say that they don't want to do this as a matter of constitutional law. So again, there are that places some limits on the kinds of advocacy that folks can do vis-a-vis the Bureau and the federal government more broadly. And just to be clear, with the court, the effect of that opinion is the court concluded in that specific case that the Secretary's decision not to adjust the census to account for undercounts was legal. The third relevant opinion is about imputation, which is a technique that folks are probably fairly familiar with after 2020, since it was used pretty heavily to respond to problems with the pandemic. When you impute, you are basically filling in gaps in the data by filling in missing information about people or households, by drawing on information from other people in households. And there's more complexities into exactly how that works and what data sets are relevant, but the basic idea is you're kind of gap filling. The court has permitted that. So in a case called Utah v. Evans in 2002, the court ruled that imputation could be used to fill in gaps in the data because it's not sampling. It's permissible under the Census Act, and the Census Act is consistent with the Constitution on this front. So what that bottoms out into is essentially imputation is permissible, sampling is not. But that leaves open questions as to, well, what constitutes imputation, what constitutes sampling, and if something is not imputation or sampling, how do we understand whether it's legal or not and on what grounds? And so, these opinions answer some questions, but they leave others open. Now, as I mentioned, the kind of frame for what I'm presenting here is Supreme Court law, but I think it's important to realize that, this case law is meaningful, but it's not large. There's all sorts of things that go on with the census that the Supreme Court has never weighed in on. And there's a lot of law that governs how the census functions that the court has never touched or has only touched minimally. And I wanted to highlight this body of law because I think this is critically important when we're talking about what can we do to try to ensure the fullest counts. And that's the question of confidentiality. So most important for our purposes are parts of the Census Act and some related laws that protect the confidentiality of the data that people supply to the Bureau. So here we're talking about the Census Act, another statute called CIPSE, which stands for Confidential Information Protection and Statistical Efficiency Act, and the Internal Revenue Code, which governs taxation. So what that law, if you kind of mash it all together or total it up, suggests is that the laws that safeguard the confidentiality of census data make 5 things clear. The first is that it's illegal for the Census Bureau to disclose census responses in any way that would personally identify a respondent, meaning someone who responded to the census. 2, it's illegal for anyone to see census responses except for employees of the Census Bureau who are sworn to secrecy under the threat of criminal punishment, including jail time and heavy fines. They're liable up to 5 years of imprisonment and $250,000 in criminal fines if they violate their oath. 3, it's illegal for the Census Bureau to disclose census responses to other government agencies. So if I give my form to the Census Bureau, they can't take that form and then provide it to, say, Immigration and Customs Enforcement. When it goes into the Bureau, it has to stay there. None of that data I submit can come back out in ways that can be tied to me. 4, it's illegal for data collected for the census to be used for any non-statistical purposes, such as immigration regulation, law enforcement of various kinds. It can only be used for statistical purposes. And finally, it's illegal, 5, for the Bureau or any other federal agency to use census data to the detriment of the person to whom the information pertains. These laws together make the Bureau sort of like a roach motel for your information. So information that goes in can't come back out in personally identifiable form. That extends to admin records that it gets from other agencies. They can go in, but they can't come back out in personally identifiable form. The law treats that kind of information like it's any kind of census response. And that is very critical because it means that government agencies kind of like can't launder records through the Census Bureau. They can't kind of give it to the Bureau and then have the Bureau give it to a third party. The things that go into the Bureau have to stay there. Okay, so I could go into extreme depth on that issue with full legal citations, but the Brennan Center produced a report last cycle called Federal Laws That Protect Census Confidentiality. This is meant to be the kind of one-stop shop on these questions. As far as I know, it's still the full statement of the law available. I'd encourage folks who have any questions about that aspect of the presentation on confidentiality to consult that report, which we tried to make very short and easy to understand. I'm going to wrap up now with sort of current issues and threats. You've heard things from the prior panelists, and I'll be echoing some of them, but just to put a little more structure on what we were keeping an eye on going forward. I don't mean to be alarmist in any sense. It's just you have to stay clear-eyed to the future to make sure you're prepared for problems you may encounter. And also to keep in mind, there may be positive advocacy that folks would like to do around these issues. It's helpful to know kind of like broadly what the legal terrain looks like when you're setting off to do that. So some of the threats. Some of the cases that I've just discussed give you some hints on what to be on the lookout for going forward. And the reason is because those cases come from conflict. People have different opinions and different designs on the census. And when they can't reach an agreement or they're in disagreement with each other, they spill over into the courts. And so the courts are both kind of resolving issues, but they're also a way of kind of spotting issues. In this current environment, we should anticipate continuing attempts both to add a citizenship question to the 2020 census and attempts to exclude non-citizens or a subset of non-citizens from both the apportionment count and the redistricting numbers. We're already seeing legislation in Congress that would do so. SCOTUS's handling of these issues last cycle are giving fodder to this. Clearly they stood up to the citizenship question, but not fully. They ducked this question of apportionment. It's sort of unclear that the court will be reliable on these going forward. but also, just take a step back from our particular political moment. This has been one of the main dynamics of the census for decades, and especially since the mid-1960s when immigration laws were overhauled for this country. Anti-immigrant sentiment and xenophobia is always attaching to the census, and it makes more or fewer inroads in any given cycle, kind of depending on the political environment at the time. But you can look back decades, and there are constantly pushes in Congress, in particular, to reduce the apportionment count and redistricting to citizens only. Another set of things we're keeping a close eye on are challenges to the Bureau's counting methods and operations. We may well see challenges to the revised race and ethnicity standards. We could see attempts to remove race and ethnicity questions from the census entirely, as well as from other federal surveys entirely, as an outgrowth of this kind of growing Supreme Court fostered idea that our law, particularly our 14th Amendment, is supposed to be colorblind. We could also see attempts to challenge the Bureau's use of imputation and ad recs and any other kinds of techniques they develop for this coming decade. I'm not saying that these challenges are likely to be successful, but they could be attempted. And a lot of these kinds of challenges arise from the lack of clarity in the Supreme Court case law about, sort of what's in and what's out. Finally, we're keeping an eye out on attempts to politicize the census. Importantly, the census needs some amount of political control that ensures that the census is responsive to the people. So when I'm talking about politicization, I'm not talking about people having input over the way the census is run. I'm talking about decisions that will override getting an accurate count in favor of pursuing other illegitimate purposes like punishing political enemies, advantaging political allies, spinning narratives, all sorts of things like that. There are activists at places like the Heritage Foundation that are advocating for more direct political control of the census, overriding experts, etc. There's also the threat of what's been called Schedule F coming back, which effectively means shifting large numbers of federal government positions to a new category where people could be fired at will. On that front, the Biden administration recently finalized a new regulation that would make this kind of mass reclassification and firing more difficult, but it is a lingering threat because it had a lot of momentum last cycle and may well return. Again, I don't offer any of this to be alarmist, but just to help folks have kind of a clear eye on what may be coming down the pike and how to get ready for it. So I know that we wanted to leave some time for question and answer, so I'm going to mute myself, but thank you everyone for coming today, listening to me and the other panelists, and we hope to see you at more census events going forward.
All right, thank you all so much. Thanks, Tom, for sharing your insights and expertise with us. I also want to share all of gratitude to all of our panelists for joining us today, for sharing their time. And I think it's important to stay informed and to stay educated in order to better defend and advocate for the census in the ACS and ultimately a fair and accurate count. So I want to also thank each and one of you for taking the time to join us today out of your busy schedules for Module 1 of the Census Seminar Series, our first one of these series. Module 2, which will focus on census and the role of Congress, will be announced in the coming months, so please stay tuned for that. Any updates and any events we'll share on our censusroadmap.org. And on that note, we'll conclude the call early to give you all a few more minutes of your day. Thank you all so much for joining us once again, and we hope to see you soon. Bye.